नमस्कार। इंसॉल्वेंसी वेटर्न्स के एपिसोड 7 में आपका हार्दिक अभिनंदन, स्वागत। I am your host Rajesh Sharma, a former member of NCLT, and I am really delighted to convey you that today we have a stalwart of IBC regime in India and NCLT, who is a former Chief Justice and founder president of NCLT, Shri M.M.Kumar. If I call him as Dronacharya of NCLT and IBC, I think I am not wrong in saying that, because he is the one who has been a friend, philosopher, and guide to all of us in the NCLT as well. Please join me in welcoming Chief Justice M.M. Kumar and Founder President NCLT. When I took the oath, Sir was President of NCLT, and it was really a pleasing experience working with him. During the course of discussions, I will be giving lot of information with respect to the working of NCLT during his period. Sir, what do you think, sir, that a talk show like this, Insolvency Veterans, is beneficial for existing members of NCLT and NCLAT, and also people who are aspiring to become NCLT member in future, for students, for researchers, and so on?
First of all, thank you very much, Mr. Sharma, for inviting me to this show and your introduction and good words which you have spoken for me. Coming to your question, I think discussions are always useful, and on a subject which is nascent in many aspects, even today, I think it must be beneficial to all those who are connected with IBC or in any way connected with National Company Law Tribunal. They may be members, they may be RP, they may be advocates, they may be chartered accountants, so on and so forth. So I believe that discussions crease out any creases which are found here and there, and the results are very fruitful.
Thank you very much, sir. Uh, uh, I will share one experience of the pleasant working with uh, Justice Chief Justice Kumar. You see, sir shared it with me during our personal discussions. In one of the case, our honorable member personally asked the honorable president about his views about a case, and the reaction which sir gave and the way he tackled that situation, he will himself tell you.
Well, I think Mr. Sharma is referring to a difficult situation in which a member has landed, and he wanted to know what should be the decision. Then I told him that you don't need any external help. Counsel from both sides are there to clarify the position. I, as a judge, and for that matter, President of NCLT, I will not interfere in your judicial working. Therefore, you should decide on your own.
You see, so well said by the sir. I can vouch this thing with full authenticity. During the entire period of my working with him when he was president and I was member in Mumbai bench, Not even a single case where he may have referred anything to anybody. And I think that must be the experience with all of us, not only me. Uh, when we talk at a personal level with our friends and so many people in the government also, they ask this question: are there some interferences? And I 100% tell them that not even a single interference from anybody in the day to day working as well as the adjudication of the cases in NCLT. That was our experience, and that is thanks to him because of his.
Judicial institutions like high courts or the Supreme Court, there is a culture that judges work independently of any influence, and nobody is supposed to or dare to interfere in the working of the judges. So, as a member of the judiciary, and that too after becoming Chief Justice, there was no question of asking any member to decide in a particular way or not to decide in a particular way. That is the judicial ethics and standard which I think honorable judges maintain throughout, and it should be like that only. The interference unnecessarily causes problems. The judge, the member who have heard the matter, he knows inside out what is to be said, what is not to be said. Such like interference are condemnable if there are any.
You see, as a Chief Justice retired, Sir has imbibed this quality in the NCLT functioning, and all the members are now independently deciding their cases. Uh, Sir, I believe when you were there as Chief Justice of Jammu and Kashmir High Court, there was some natural calamity came into came out, and you had to deal with a very difficult situation because of that natural calamity. Kindly say a few words about that and share your experience.
Now, when I was Chief Justice on 7th of September 2014, floods razed the capital city Srinagar. The water started rising in the city houses, and about 2 o'clock we were rescued from the Chief Justice house because the water has reached Badami Bagh by that time. So there was fear that the water will enter the Chief Justice bungalow. So we were taken at 2:15 exactly to Hari Niwas, which is a official guest house, and we found reaching Hari Niwas that there were many others like me, officials, ministers, who were shifted to Hari Niwas. Then the question was, when I got the information that district court in Lal Chowk were under 18 feet water. My house, that the Chief Justice bungalow, was under 8 feet water by the evening of 7th of September, 8th of September, and High Court was under 10 feet water. Then I sent a handwritten request which was written by my daughter because there was no stenographer, there was no Wi Fi working. So I sent a handwritten request to the governor that kindly allot me some lands so that I may run the High Court and the district courts. My request by Honorable Governor Shri N.N. Bora was forwarded to the Chief Minister. The Chief Minister and the Cabinet met in the Hari Niwas itself on the ground floor. We were on the first floor, and they decided that there was no space for allotment for the High Court or the District Court. A very sad, grim situation developed because courts can never be closed because of reason ABC. The door of the justice, they must remain open. So therefore, I consulted my registrar general. The registrar general told me that there was a house which was allotted to a judge, 5 Gupkar Road, and it is at the high ridge area. There is no possibility of water coming there. So I got into my head the idea that why not to shift the High Court temporarily to that house, because the government has declined my request to allot any space. So 5 Gupkar Road became the new address of the High Court. And District Court, I allocated the university moot courts. Two moot courts were made, District Court for the North Kashmir, and for South Kashmir there was a office lying vacant of Revenue Department. So I allotted that land. So the matter of North and South Kashmir were separated. Then very interesting thing happened in the High Court. Insurance petitions started coming in. Large number of people who have the insurance against their property against floods, they filed those petitions that they should be given compensation. Now the law of insurance is that surveyor submits its report, and unless surveyor give the report, the court is handicapped in awarding any insurance amount. When I asked the surveyor of various insurance companies, they told me that it will take at least 1 year to 18 months for them to submit the report. Then we devised, innovated a method that 50% of the insured amount be disbursed to the affected persons immediately without any delay. And the result was phenomenal. The insurance company had to shell out something like 289 crore, and the all business houses were re-established within few days. That was a very happy sight. And there was some criticism that the division bench of the High Court has committed illegality, and our order was tested in the Supreme Court. Supreme Court dismissed the SLP, knowing fully well that Chief Justice himself has suffered. There is an extraordinary situation, so an exception has been carved out. We must uphold it. Now, when I go back in 2018 to Srinagar, the Confederation of Indian Industry people, they told me that, sir, there is a great benefit which has accrued to insurance companies. I said, how? I said, earlier, if there was 7-8% people who were going for insurance, now more than 40% people go for insurance. So the system, when runs well, it gives the result. If it is because the people started having confidence that if you have the insurance cover, High Court will have it recovered. So go for insurance. And sometime once in a blue moon, such like tragedies happen, natural calamities come, and the insurance companies may have to shell out some money. But otherwise, insurance business, you see, flourishes like anything.
It is well said that if there is a will, there is a way. And Sir has proved that the High Court can function under the grave circumstances and so adverse circumstances from a makeshift court. Sir, before taking over your charge as president of NCLT, you were chairperson of company law board also. So that way you have seen pre-IBC as well as post-IBC regime, and that too from such close atmosphere where you were chairperson of CLB and president of NCLT. For the benefit of viewers, uh, kindly share your experience as chairperson of CLB as well as as president of NCLT, and what is the basic difference which you found between the two regimes?
Well, under the company law board, the jurisdiction were confined only to few areas of company law.
Yes.
And there was no insolvency bankruptcy court. And when the National Company Law Tribunal was established in June 2016, then the talk started. Company Law Board has a very limited work, and there were few members, and some mm, outstation benches were also functioning, but the strength was only 7, 8 total members all over the country. So that was much less a very light type of work, and it was in a way relaxing that after such a burdensome uh, duties of a chief justice, I took over as a chairman company law board. But still, many cases of 396, 395, 96 directors disputes, those were decided in the old building where later on appellate tribunal started sitting. But in June 2016, when NCLT was formed, the IBC was still not implemented. Insolvency bankruptcy code was implemented and enforced in December of with effect from 1st of December 2016. I remember the finance minister was in Japan, and the finance minister would keep ringing the secretary corporate affairs and me that we must make national company law tribunal functional, and according to him there would be 63 members, and the recruitment process was on. So I requested the finance ministry that there is hardly any infrastructure. How can we start functioning for the members? And IBC is a brand new code, and people have to be imparted some sort of instructions that how and what does it mean. But the ministry was very, very insistent, and we have to agree that from 1st of December 2016, the IBC will be implemented and cases will start flowing in. And secondly, all cases which are pending and are covered by IBC must be shifted by the High Court to the National Company Law Tribunal. So that process was completed at the earliest, and the infrastructure, for example, Bombay suffered for quite a few years before we could bring the present infrastructure, because earlier there was very, very uh, insufficient infrastructure which was under the company law board, because the volume of work at that time was very small. So there will be hardly 5 chairs in front of the honorable bench in the old Bombay bench. Calcutta still is suffering. Calcutta new building would be coming up. Ahmedabad, we have a beautiful complex. Chennai, we have renovated the old complex, which is the corporate bhavan. And Kochi has a beautiful complex. Even Hyderabad, although it is a bit far, that is a very, very good complex. So, like that, NCLT infrastructure became the primary responsibility which I took, and I was able to establish a good infrastructure, but still there are some further requirement which can be improved upon.
Actually, it is well said that if the foundation is laid, a strong foundation, the further floors will be, better laid. And I must compliment former President NCLT for laying the good foundation stone for NCLT to work upon it. Sir, when we were thinking about this today's particular topic of IBC and PMLA, we thought that nobody better than you can throw light on this subject, because you worked as Chief Justice of High Court as well as President NCLT, and you know the intricacies of both the institutions from High Court side as well as NCLT side. Uh, Sir, how do you view that the recent Delhi High Court judgment, first Nitin Jain, liquidator of PSL Limited and versus GD, and thereafter further decisions, that the power of ED to attach properties under PMLA ceases to exist when an order of liquidation has been delivered under the Insolvency and Bankruptcy Code. For that matter, I would divide my questions in three segments. One is that attachment of the assets of the corporate debtor before initiation of CIRP, during initiation of CIRP, and later on during the process of liquidation. This particular question is based on a case where the liquidation proceedings were going on.
Well, Mr. Sharma, PMLA and IBC, both statutes have their roots in the society. There is a regime which has now been demolished to larger extent, that borrow the money from the bank and forget about it. The borrower used to think that once you have borrowed, say, 1,500 crores from the bank, and nobody is there to keep a check on you where that money has gone, how it is being spent, whether there is any project or not. The experiment under SICA failed because there could not be any recovery. As a result, the non performing asset ballooned, as in accordance with one estimate, 11,500 crore in 2016. That was the figure which popularly was circulated. So the government thought that how to arrest it, how to instill financial discipline. As a result, IBC, which has been enacted in Singapore a year ahead of us, and in a country like England from 1986, it is, and in USA even earlier. So therefore, to instill a financial discipline and to control the NPAs, the Insolvency Bankruptcy Code was brought in so as to resolve the non-performing assets, so that they may start generating finance for the country rather than getting stuck in one industry or the other. The object was to maximize the assets and to resolve it by bringing back in the mainstream those assets so that they may start performing to advance the interest of the country, economic interest of the country. Now, PMLA, for example, Prevention of Money Laundering Act 2002, that was obviously brought because in our country a parallel economy has been running. If you have a transaction, and ordinarily it is said that some part would be under the prohibited regime some part would be by the bank transaction. How to arrest this tendency? So it was an object of money laundering, how people are. And I have given a very small and I mean insignificant example, but offshore, how the money goes from India, go to foreign land, come back in India, all that is known to the ED. In order to arrest this tendency, strict provisions have been enacted in the form of Prevention of Money Laundering Act. Now, both the acts have a very pious object to achieve, and those who are indulging in these type of practices, they know very well that this is unlawful, and particularly after 2002, they would be under the eyes of the ED. Now, the question is both the acts aim at reforming the society one way or the other. How to give preference to the one over another? That is the question. 2019, the amendment by Act of 2020 with effect from 1st of December 2019, the amendment was brought in the Insolvency Bankruptcy Code, and Section 31 capital A was inserted. And it is a very comprehensive section. And if you read it, just plain reading, its plain reading would show that the offences committed by corporate debtor before admission of the corporate of the petition under
Into
section
insolvency.
7, 9 or 10, that those offences would no longer haunt the corporate debtor. Before that is at the time of when the corporate insolvency resolution process have started. But you have divided this in three stages: pre insolvency process, post insolvency process,
And during insolvency.
and when the liquidation process has started. Now, before corporate insolvency resolution process starts, there would not be any moratorium. There would not be any bar on the PMLA. Under the PMLA Act, the authorities can act against a corporate debtor. There cannot be any doubt because Section 31 capital A itself makes it clear. Now, with regard to uh, the second stage, when the corporate insolvency resolution process has started, resolution professional has been appointed, Section 14 moratorium has been imposed, the section itself makes it absolutely clear that no, the offense committed by the corporate debtor would not continue. Having said that, but it does not mean that the directors who are guilty of any offense, they are exonerated. The reason and the rationale is when the corporate insolvency resolution process starts, rights of third parties start coming in. In order to protect the right of third parties, number one. Secondly, to give a cool period to the committee of creditors as well as to the resolution professional, this scheme has been made. Otherwise, if side by side every offense is being tried against the corporate debtor, every suit is being tried against the corporate debtor,
No resolution can come.
no resolution can be
Yes.
solved.
Yes.
Therefore, the scheme of the Act is allow a cool period of corporate insolvency resolution process to complete so that the resolution may come and the company is restored back to its status creditor get their money back, the new regime may take over, they may start working with the better management, with the better uh, credibility. And similarly, if there is a liquidation process, you see, there are two ways when the corporate insolvency resolution process may result in. One is somebody present a scheme, and that resolution applicant may ultimately succeed. It can be resolved by paying the creditor the amount of money, as you know. And the second is there are no taker, no resolution applicant, there is no success,
Company
committee of
goes
creditor is dissatisfied, it goes into
liquidation.
liquidation.
Yes.
Now, even at the stage of liquidation, the same principle would apply, and I'm happy that in Nitin Jain's case, Delhi High Court single bench, uh, Justice Yashwant Verma
Yes.
elaborately has dealt with various provisions, their interplay, and the object scheme of various acts. And I think eventually he has reached to the learned judge has reached to a right conclusion that PMLA, after the corporate insolvency resolution process, must give way to the insolvency bankruptcy code.
As a matter of fact, sir, Nitin Jain's case in as liquidator of PSL, that is the law today which is being enforced till the time Honorable Supreme Court comes with a decision
Yes.
on various appeals which have been consolidated in a
Yes.
single case.
No, you are right. You see, the judgment of the learned single judge was subjected to appeal.
Yes.
Appeal dismissed. Now all these matters are now before the Honorable Supreme Court to take a decision. I can share with you uh, under the Negotiable Instrument Act, if a check is dishonored under section 138, it is an offense, complaint is filed, and the defaulter is tried. Supreme Court has already taken the view
Yes.
that moratorium would apply and corporate insolvency resolution process, if is in operation, then that trial will stop. So the tilt is there are two ways. These two acts have to work complementary to each other. Both are aimed at curbing the illegal tendencies
The bad
prevailing in the
practices,
society
yes.
for the long time. This money laundering business, as well as borrower tendency to misappropriate the bank loan, both are, you see, were widespread. And these two acts are rendering human services to the society, that you better reform, you better understand these illegalities are not being tolerated by the country. So therefore, I think we are looking forward to the views of Honorable Supreme Court on the judgment of Delhi High Court. The division bench, after dismissing the appeal, uh, the ED is in appeal before the Supreme Court. Let us see.
Actually, sir, my first question was with respect to the three stages of insolvency process and what is the law which is laid down as on today in each case. First, I'll take it up as attachment of property before moratorium starts. There are three leading cases. There are many cases, but three leading cases. One is Varsana Ispat Limited, second is Kiran Shah versus ED, and third is ED versus Manoj Kumar Agarwal. In all the cases, uh, the three of the cases were in NCLT. During and the attachment of property during moratorium, there are two leading cases, Rajiv Chandrasekhar versus ED and Ashok Kumar Saraugi versus ED. During liquidation, we have already spoken about Nitin Jain, and Welspun Steel Resources Private Limited, where the buyer of the property filed a case. Sir, whenever Supreme Court decides, I know as on today the position is not that clear to everybody, and different high courts have given different decisions.
Yes.
Once the situation is clear, I think Honorable Supreme Court would be clearly distinguishing between the pre-CRP, during CRP, and liquidation stage, and as to at which stage what will prevail.
Yeah.
Sir, the basic purpose of IBC is to resolve the problems of the corporate debtor.
Yes.
IBC is not much connected with the personal problems of the directors and shareholders, and to that extent, if they have done something wrong, PMLA proceedings will continue against them, but will stop during the moratorium period against the corporate debtor. I think the broad parameter of the law is
Yes,
this.
yes. That is absolutely correct.
Huh.
You see, the attachment pre-corporate insolvency resolution process will continue, but it will remain under eclipse for that period only. But it can revive thereafter.
Incidentally, sir, what a practical difficulty which I have observed with respect to the attachment. See, you are well aware that the moment assets are not kept in use, these depreciate and diminish very fast when the asset, in comparison to the when the asset is kept in use.
Yes.
And once the attachment is done and the asset is not kept in use, uh, a simple solution which can be thought of, that the resolution professional or liquidator can be allowed to deal with that asset and dispose it off according to resolution plan or liquidation, deposit the receipts of that into with ED, and depending upon the decision whether it goes in favor of the corporate debtor's assets or against corporate debtor, those money can be given to the resolution professional or liquidator, as the case may be.
No, you see, this suggestion is very good. Under the old regime of the Companies Act, when the winding up proceeding used to take place, the official liquidator would be made the official receiver as well. So it was the duty of the official liquidator to keep supervision of the uh, company under the winding up. So if this is a huge company, it requires the services of guards. We, under the as a company judge, I used to sanction that 10 guards are sufficient, 5 guards are sufficient, and if then they are not found to be on duty, then official liquidator used to be uh, under a lot of questioning. So I don't think ED can simply afford to attach the property and turn its back on it. The official receiver, in all cases, must act in under the CPC. Official receiver provision is there in all cases which come under the custody of any institution or any court. Official receivers are appointed and they keep account of, for example, if you have overtaken an industry which is a running industry and the products, and for a little while it may stop, but you appoint somebody sufficiently equipped with skill and knowledge to run that industry, it must run. The worker must come the way they were coming before that. Attachment would not mean that the attachment should merely means that it shifts from one hand to the other so that the control may not slip into the hands of those who are facing the criminal proceedings. The proceed must be kept in escrow by the official liquidator, official receiver, and the industry must run, workers' interests must be watched, the corporate debtor interests are watched because it is running the way it should. But unfortunately, the experience is otherwise. That should stop.
That is what the point was.
The suggestion given by you, I think, is very, very fruitful, and it should be considered by the authorities.
Uh, Sir, you know, a major carve out has been created through this Nitin Jain's judgment. Uh, what is your opinion with respect to attachment of property of the corporate debtor during the CRP when the resolution plan has been approved or when the resolution plan has not been approved? Will there be a change in the circumstances in two cases? Because the moment resolution plan is approved by the adjudicating authority, the third party rights are created,
Yes.
and there are cases pending in the courts where even the resolution plan has been approved. ED is challenging this question in the courts, stating that resolution plan only has been approved, the money has actually not come because it will be coming in installments, and hence the rights of ED remain the same. This is what the plea is taken by ED in many cases in resolution. Similarly, in liquidation, sir, in liquidation also, whenever the assets are with the liquidator, the position at that stage, and when the liquidator has already sold the property to third party, and with the confirmation of NCLT, that has gone to the prospective buyer. So at every stage, will there be a difference, or these will be same?
Sharma, I think the answer to this question is, I don't think, legally speaking, ED is correct in thinking that after the resolution plan has been approved, then they have right of attachment, because 31 capital A itself creates a bar. Secondly, there should be slight improvement once the resolution plan has been approved by the Company Law Tribunal, National Company Law Tribunal. Then, along with the RP, the successful resolution applicant H1 should be associated in some way or the other, because he has paid the earnest money. He is entitled to keep, because when the resolution plan is presented, he presents the resolution plan in accordance with the assets
Law.
on the date of presentation of the resolution plan. Now, what is happening, that resolution applicant, by the time he gets complete possession, the property is further diluted. If he is associated, then
He will
large
have-
number of applications which are now being filed, because the corporate insolvency process has not completed in 3 or 4 years after the approval of the resolution plan by the NCLT. Appeal, Supreme Court remand, so it is happening. So the resolution applicant says, sir, 3 years ago, I presented a resolution plan, and on the basis of that resolution plan, I should have been treated. But 3 years later, it is all upside down now.
Based on the conditions prevailing at that time, I had given the resolution plan. Now the situation is changed. Either may be allowed, I may be allowed to move out.
No, the Supreme Court said no.
But
Supreme Court in Exim case have said
yes,
that a resolution applicant cannot be permitted. So therefore, the third party right has come into existence as per the present law, but it has not concretized in the sense I am trying to project. If the resolution applicant is given say in the management and the day-to-day working of the uh, corporate debtor, I think it will strengthen the regime further, and the RP burden is also reduced. RP will be happy that he is running around unnecessarily. So, some association, some participation, then I would say that Supreme Court is absolutely right that after 3 or 2 years resolution applicant who is successful cannot come back and say, sir, I want to move out.
Uh,
Then he has already taken a step which would, and the ED certainly will not be correct in either situation
uh,
to order attachment. And in Jashwant, in the Nitin Jain's case, they passed a provisional attachment order,
yes.
and counsel for ED
And they want,
conceded that
yes.
there is no provision for provisional attachment order. He
It was
conceded.
not confirmed by the adjudicating authority. It was a provisional order. Right?
So therefore,
Mm.
that was a very fragile situation.
Yes.
Because the Nitin Jain moved at a time when there was no attachment order.
Mhm.
So the court has proceeded on that premises that now the resolution, the attachment, provisional attachment order which has been passed, it has no meaning, and the council conceded.
Sir, there is a provision clear cut that the resolution applicants, once his resolution plan is approved, he cannot go back. There is a clear provision. I have a slight, practical experience on this, sir. It is not related to ED or PMLA.
Mhm.
I'll give you one example, sir. A resolution applicant, in all his goodness, in right earnest, he submitted a resolution plan. He submitted the earnest money also. He is abiding by that. You know, basically, IBC is a business law. It has to first see the business and then anything else.
Yes, yes.
Continuance of business, moratorium, because of moratorium, having a resolution plan, basically business law. Sir, which law in the world can tell somebody to continue incurring losses and be in business? Nobody can.
Nobody can.
What maximum the courts can do is, whatever money has been invested by him, he may not be allowed to take back. But can somebody tell him or force him to be in business and continue incurring losses? I don't think it can be done.
Ms. Sharma, it is like this. It has been very well known to all the resolution applicant or the bidder under the old regime under the Companies Act, when the winding up concept was there, that they are buying litigation.
Yes. And they are
And secondly, they are buying this the corporate debtors asset at a 20% rate, 30% rate. The haircut is huge. Therefore, these are all very calculative. There is no question of any loss. I don't agree with this proposition that they will be incurring losses. They are successful resolution applicant. They know fully well that if we succeed up to Supreme Court, we will end up spending X amount. Still, we will be beneficial if we spend, say, 5 crore on the litigation. They know it very well. They plan it. Therefore, they buy litigation. They calculate it very well. They invest it in that very fashion.
No, I'll give you an example, sir. A project which was thought a profitable project by the resolution applicant, maybe at the time of application, there is a possibility the circumstances have changed, climate has changed, business requirement have changed, and the product may have become obsolete by the time 5 years later. What my point is, even if Honorable Supreme Court will be, one once a resolution plan has been given by him, he has submitted certain 30-40% of the amount, 1 year, 2 year have done, and after that, if he finds that he is unable to continue with it, Sir, with respect to this resolution applicant stepping into the shoes of the company and resolving the company, uh, the provisions are there that he cannot withdraw. Once he has submitted a resolution plan, he has to implement it. I have a small observation on that.
Yes.
You see, a resolution applicant submitted the resolution plan, provided the earnest money deposit, invested the money in that. However, the entire payment is to be made in staggered manner in next 3 to 5 years, or whatever the resolution plan is telling about. Sometimes it happens that even the adjudicating authority stays, or NCLT stays, or Supreme Court stays, the resolution plan is into litigation, and finally he is handed over some property after 3 years or 5 years or whatever is the period time taken during the adjudication process or the with the judiciary. There can be a possibility where by the time we finally tell him to implement the resolution plan, or even if he started implementing the resolution plan, later on he finds that it is a loss making preposition on day to day basis, he is incurring loss. uh, you will agree that after all IBC is a business law. The basic senses of business, the business should flourish. I can understand that once somebody has made a resolution plan, he has to adhere the covenants, he has to continue with the resolution plan, and he has to implement it fully. But if he finds that on every day he is incurring loss, I don't think any law in the world can ask somebody to continue incurring losses and to be in business. What maximum we can say is that whatever you have invested, that will not be given back to you. If you don't want to continue, you don't continue. We will not be returning the money what you have invested. But we cannot ask somebody to continue incurring losses after the stipulated period of 1 year or so. This is what my take is.
No, Ms. Sharma, you are right that nobody would like to continue investing in a loss-making business. In a loss-making business. But when a resolution applicant presents the resolution plan, there is adequate safeguards. RP apprise him of everything, information memorandum, all the information, inspection, market forces. After taking advice, only then he steps in.
Yes.
Now, if the market forces have changed, say in a year's time, 2 years' time, or there is loss of assets, which he thought would remain intact, there is a possibility of walking away from the uh, resolution plan and filing an application for withdrawal. But if a resolution applicant has not examined the whole proposition, you see, when the resolution applicant applies with a resolution plan, he takes the advice of experts, whether it is a loss making or it is a profit making. Rarely, I think, it happens. As I was mentioning, there are matters before the court where the assets have evaporated. If, say, there is industry, I am now taking hypothetical, on the seashore, tsunami has come and
Nothing is
the
left.
industry has been wiped out.
Nothing is left.
Nothing is left. Maybe in an exceptional case like this, it is not a question of loss making, it is making nothing. It is making nothing. So, in a situation like this, yes, uh, but ordinarily, the resolution applicant has to adhere to the resolution plan, and incidentally, if it is incurring into losses, then you see, otherwise, what will happen? Any person who is applying after 3 years, he says, no, this is not loss making business. Now, if there is a liquidation process, in liquidation as a running concern, he buy. Then he says, no, sir, I cannot run it. So, this is endless process then.
No, liquidation as a running, in liquidation as a continuing business or running business, if takes, he is to deal with it. He is to deal with it. But certainly, yes, once you see, you cannot ask somebody to continue incurring losses on day-to-day basis and be in business, because either you have taken an asset in liquidation or in resolution plan, provided the statutory period of 1 year is completed, and we are right in saying that the money will not be returned to you whatever you have already invested.
No, then you see, then how the resolution is to take place. Now, if that proposition is accepted, then there would be question of coming back to the committee of
Again,
creditors.
IBC,
IBC.
again IBC will be
You see,
into force.
then in such a situation, which bidder would purchase such a property?
You see, we are just
Then you see, in the market, such asset would be completely diluted. The experience of the earlier resolution applicant or the bidder in the liquidation process, that would be widely known. Nobody will be there. So virtually it is becoming a dead property.
Dead property or no property at
No
all.
property.
This the example which you just gave, that tsunami came and nothing is.
So therefore, Supreme, and then some amendment has to be there if your point of view is to be incorporated. Because presently there is a
1 year is there, no?
1 year is there.
After that, it will again come into IBC.
Oh, okay.
It may be diluted value against 120, against 20 now 2.
No, I am talking 1 year period is there, but that also the NCLT has to examine under what circumstances he is withdrawing.
Yes.
It is not
absolutely
that,
yes. And even if he comes with a proposition that, my lord, see my books, every day I am making a loss. But I don't think I can be asked to continue incurring losses. That
could be.
So, sir, on this PMLA versus IBC issue, I think broadly we have discussed almost all the aspects. As far as this, now again, one question comes in mind, that of course Supreme Court will only be deciding that if there is a tussle between the two, or if there is a overriding provision both are having with each other, which one will prevail?
Yeah. You see, firstly, I would say the object of both the acts is entirely different. Whether there is a conflict or not, that will be a very big question. Conflict would be only to this extent, whether allow the ED to order attachment and sustain that order after the corporate insolvency resolution process has started, or ED cannot touch the asset of the corporate debtor. I think this is the correct view. That now the other big question which arises, the criminal law has been enacted with the object of keeping the criminals separate from the society.
Yes.
It may be white collar crime, it may be otherwise under the Indian Penal Code. So this is also very, very important aspect which will be decided by Supreme Court, whether allow the resolution process and give preference to the resolution process over the basic object of criminal law, that keep the criminals away from the law-abiding people. The basic object of criminal law is that all criminals should not be able to rub shoulder with the law-abiding citizens. Society should be kept clean.
Yes.
Now, this is a very, very wider aspect which needs to be debated. You prefer resolution over people who have committed crime. But having said that, a corporate debtor as an entity would undergo change. Resolution applicant will replace the former director and the managing director. New management will come. The earlier management is not immune. So criminality which is attached to ABC in the management,
it will continue. It will continue, and the law will take its own course against the person. not against the project. Project
Yes.
will be taken out of the.
Therefore, the view taken by Delhi High Court, I think, is very sound, on a very sound footing. It is likely that the Honorable Supreme Court uh, would endorse this view.
Sir, one question also comes in mind of everybody: whether ED can be considered as a creditor for the corporate debtor. If so, in which capacity?
ED, ED as an agency has no trapping of becoming a creditor. I don't think ED can. You see, ED works under the Prevention of Money Laundering Act. There is hardly, I don't find any provision in the PMLA for the ED to play the role of a creditor.
It's not. Uh, you know, PMLA proceedings are criminal proceedings. And many a times it may have happened that from the proceeds of crime, the assets have been created in the corporate debtor. So during moratorium also, can ED, can the PMLA criminal proceedings continue against those assets which have their origin from the criminal proceeds?
Now, if we go by the language of 31A, no proceeding can go.
Yes.
And the way it is interpreted by Delhi High Court, under single judge, and then division bench dismissing the appeal, I don't think it is possible. It is sort of a condoned offense because third party rights have come in. After, in the corporate insolvency resolution process, if you examine widely, in a wider way, broad way, then some third party rights at one stage or the other keeps coming in. It will affect those who are otherwise law abiding. It will keep on um, haunting those who have committed the crime in their personal capacity, that is earlier management. So that is what Delhi High Court has also said, that they are not immune. They will continue to be under the eclipse of criminal law. They will not be exonerated.
With this, we are coming to the concluding part of the seventh episode of Insolvency Veterans, and we had a very lively discussion with Honorable Chief Justice retired and founder president of NCLT, Shri M.M.Kumar. I hope that the Honorable Supreme Court, while deciding on the issue of prevailing IBC over PMLA or PMLA over IBC or coexistence of both of them in different circumstances, that is attachment of assets of CD before initiation of corporate insolvency resolution process of the corporate debtor, that is part A. During CRP, the attachment by PMLA of the assets of the corporate debtor, it will be subdivided into two parts, that is before approval of resolution plan by the adjudicating authority, and second is after approval of the resolution plan by the adjudicating authority, and finally, if in liquidation, then if the assets have been transferred to third party or the assets have not yet been transferred to third party. We hope that Honorable Supreme Court will be giving final verdict on this account, and till the time we have to live with it. Thank you very much. Thank you.
Thank you.
Thanks
So much.
for coming,
Thank
sir.
you.